Will the gentleman from Cavite continue to yield the floor to some questions and manifestation?
Mr. President, I continue to immerse myself with the questions, with the sapient and judicious questions coming from the legal luminary, the minority floor leader, Mr. President.
I do not pretend to be a legal luminary, Mr. President. I am an ordinary senator. Anyway, Mr. President, Mr. President, I have thoroughly reviewed and read the privileged speech as found in journal journal dated July 29, 2019 for session number 4. Mr. President, I thank the gentleman from Cavite for putting forward a number of novel legal theories. Many of these I heard for the first time after being almost 50 years as a lawyer. These theories, however, Mr. President, are not settled. I am prepared to debate on the propositions here and now, but we do not claim to have a monopoly of legal knowledge. That is why we qualified and denied the attribution that we are a legal luminary. In instances such as this, Mr. President, it is best that the validity of such novel theories be tested through a debate. The best avenue to thresh out the validity of these novel propositions is in a committee hearing, not on the floor. I am interested to hear the thoughts of legal luminaries and recognized experts in international law on the proposition being put forward by the gentleman in his privileged speech. Let me enumerate, Mr. President, some of these novel legal theories. On page 73 of our journal of Monday, July 29, left column, fourth paragraph, there is a statement by the good gentleman from Cavite. Quote, "There is no restriction on either the form or substance of international agreements." End of quote. Following this proposition, Mr. President, can the President of the Republic enter into an oral or even a written agreement ceding the island of Panay, even if as it is contrary to Article 1 of our Constitution on national territory? If there is no restriction as to form, can multilateral agreements be in the form of an oral agreement? I cannot imagine the confusion and difficulty of enforcing a verbal multilateral agreement. Can we enter into an agreement that is in conflict with the Constitution, despite the latter being an internal law of fundamental importance, if we say there is no restriction as to the substance of the verbal agreement? Mr. President, the gentleman also makes a forceful assertion that matters of foreign policy are within the exclusive and absolute power of the President. As I said, Mr. President, there are many more propositions that can be subject to a debate and interpellation. And in this regard, that I congratulate this gentleman for putting forward these novel theories and single-handedly opening up the discussion on complicated issues surrounding the West Philippine Sea. The inquiry, which will be conducted by the Committee on Foreign Relations, was made possible by the early and timely manifestation of the gentleman.
I would just like to conclude that all my theses are based on the President as the Chief architect of foreign policy, acting based on constitutional grounds. Secondly, the matter of oral agreements are done on a bilateral basis.
Thank you, Mr. President. I have already manifested earlier that we are willing to discuss these issues in the committee hearing. But if a gentleman wants to debate on the floor, we are ready, Mr. President.
Mr. President, I defer to the decision of the minority leader that perhaps the Committee on Foreign Affairs or perhaps the Committee on Constitutional Amendments can be involved in as a secondary committee in so far as the referral is concerned.